Hello, good evening. Hello, everybody. Hello, welcome. Good to see you. Welcome in, everybody. Yes, tonight we're going to go through the Michigan Sanctions case. Hello from Florida. Hello, welcome. Good to see you. Welcome on in. Hello, Mary. Lisa, good to see you. Welcome. I had to take a couple of days to catch my breath, but I'm back. All right, sounds great, Kristen. From Australia. Yes, everything's going pretty good today. It's been a pretty decent Monday, and I don't often say that, so I think that it's been going just fine. So far. Yes, thank you, Tina. Yes, I needed a little bit of a break, so I'm happy to be back. Yes, caught my breath. Yes, I needed a little bit. Last week was bonkers, but this week should be great. Should be good. Fireworks tomorrow. Maybe we will see. We will see what happens. Yes, from North Carolina. Well, welcome. Good to see you. Thanks for coming by. Yes, I'm back. I'm back. Definitely needed a couple of days to rest my voice, but back, and I'm glad to be back. So, hello, Vicki. Hello, welcome. Yes, keeps you from watching the news. Hey, fair enough. Me too. From Michigan. Well, hello, Snappy. Good to see you, South Dakota. Love that. Nails look great. Thank you. Little Halloween vibe tonight. Just a little bit. I'm getting ready. Getting ready for my big Halloween nails, which will be coming up. Coming up pretty soon. I was getting withdrawal. Oh my goodness. No, we can't have that. No. Oh my gosh. Okay. From Washington. Hello. Yes, St. Louis. Hello, welcome. No, I haven't seen where Jenna Ellis is going to flip. I've not seen that yet, but I wouldn't be surprised. Et al. Means everyone else. So there's just a whole bunch more people. They're not named. So that's kind of our abbreviated way of saying a whole bunch more people. Yes, TikTok technology. Yeah, I have to work on that split screen for next time. Oh my goodness. Oh, yep. Yes, I believe he'll be joining us again sometime. Absolutely will be. That was pretty fun. So we'll definitely be doing that again. It's a pretty good time. Lots of good information. So he will be joining again sometime soon. I'll give you a bit of a heads up for sure. But tonight I've got our Michigan case. This was the case where the judge issued sanctions to all of the Trump attorneys that filed all of the fraudulent cases for the election cases. So it's so well written. I thought I'd take everybody through it tonight. It's really exceptional. It's a really, really well written order that explains what lawyers did what, how they did things wrong, why they need to be sanctioned for doing things wrong. I thought this judge really doesn't hold any punches back, so she does. She does a pretty good job. Linda from DC, well, hello, good to see you. Yeah, so I thought it would be pretty good. I will probably go at a pretty good clip tonight just so we can make it through rather than spacing it out over too many nights. So I'll probably go, again, at a pretty good clip and do most of the Q&A after I'm done going through. But it's a really, really good, really well written, again, and it really outlines everything so well and all of the cases that were filed and so on. So, well, Mary, I thought this would be good because Ms. Powell is part of this case too, and what she did and her role and the various ways that all of the attorneys involved, including Ms. Ellis, were involved in all these lawsuits. So this should be pretty informative. So, and it's just so well written. So I'm very impressed with this. Diehards, that's so funny. Oh my goodness, that's so funny. Yes, well, welcome everybody. Yep. I'm gonna wait just a couple more minutes so I hit that 7 o'clock time. but I will be getting in pretty soon here. Cool nails. Oh, thank you so much. Appreciate that. Yes, 12-year-old is waving. Oh, that's so sweet. Oh my goodness, that's so sweet. Yes, poor Sydney pled guilty before she could even, well, right, yeah, she didn't get to release the Kraken, but I mean, sometimes that's okay. These things happen. From Rhode Island, yes. Yep, Barry, we're almost there. I've got 2 minutes left on my clock, and then I'll be diving right in. Oh my goodness, yes, my Halloween nails for tonight. But welcome in, everybody. Good to see you all. So let me just do my little, Nevada. Okay, hello. So glad you're here. Oh, thank you so much. Oh no, I'm so glad to see you. I'm glad you're back. Yes, I'm here and having some fun tonight. So it was unacceptable. That's so funny. Oh my goodness. All right, everybody. Ooh, New York too. Okay. I'm distracted saying hi to everybody. Well, welcome back, everybody. Here we are. We're back in it to win it. So here we go. We've got our calendars wide open now because we do not have a trial going on today. So we've got a lot of fun things that I can catch you up on. I've got lots of great things planned for the next few days. So hopefully you'll all come with me. Tonight, though, what I wanted to do was take you through, this is the King versus Whitmer case, and this is the Michigan case where we had a judge come in and say to all of the attorneys filing all of the election fraud cases, basically saying, you guys are all out of line, and why you're out of line, and here's some sanctions. So it's a very well-written opinion by Judge Parker in Michigan. She does a really good job breaking down what all of the different attorneys were doing and how they were filing things and why it was unacceptable. So I thought this would give us a really good overview of the attorneys that were involved because so many of them are still waiting to plead, haven't pled out yet in Georgia. So I thought this would be a really good overview for us to go through. So I will go ahead and get started then, everybody. I do have my sticky note. Now, for this one, because it is a little bit of a longer order, I'm really going to go at a pretty good clip to get through it. I do want to get through it tonight. So I'll probably, even though I'm going to leave the comments on, I will just kind of be reading through the order and then really do a more in-depth Q&A at the end. So if I'm not answering your comments, I'm just going to try to get through the material first. I didn't want to turn the comments off yet and just try to see if we can do this kind of hybrid situation and see what happens. I've got 2 mugs of tea. I'm ready. I'm definitely ready. All right, so here we go, everybody. We've got our Michigan case. Again, it's King versus Whitmer and City of Detroit, Democratic National Committee, Michigan Democratic Party, and Robert Davis. Here's the opinion and order. This lawsuit represents a historic and profound abuse of the judicial process. That's pretty powerful right out the chute. It is one thing to take on the charge of vindicating rights associated with an allegedly, sorry everybody, there's somebody honking for somebody outside, with an allegedly fraudulent election. It is another to take on the charge of deceiving a federal court and the American people into believing that rights were infringed, without regard to whether any laws or rights were in fact violated. This is what happened here. Pretty strong words. Yes, this was in 2021. I'm not sure very many people have actually even heard of this, even though it's an incredibly powerful opinion. Individuals may have a right within certain bounds to disseminate allegations of fraud unsupported by law or fact in the public sphere, but attorneys cannot exploit their privilege and access to the judicial process to do the same. And when an attorney has done so, sanctions are in order. Here's why. America's civil litigation system affords individuals the privilege to file a lawsuit to allege a violation of law. Individuals, however, must litigate within the established parameters for filing a claim. Such parameters are set forth in statutes, rules of civil procedure, local court rules, and professional rules of responsibility and ethics. Every attorney who files a claim on behalf of a client is charged with the obligation to know these statutes and rules as well as the law allegedly violated. Specifically, attorneys have an obligation to the judiciary, their profession, and the public, 1, to conduct some degree of due diligence before presenting allegations as truth, 2, to advance only tenable claims, and 3, to proceed with a lawsuit in good faith and based on a proper purpose. Attorneys also have an obligation to dismiss a lawsuit when it becomes clear that the requested relief is unavailable. This matter comes before the court upon allegations that plaintiff's counsel did none of these things. To be clear, for the purpose of the pending sanctions motions, the court is neither being asked to decide nor has it decided whether there was fraud in the 2020 presidential election in the state of Michigan. Rather, the question before the court is whether plaintiffs' attorneys engaged in litigation practices that are abusive and in turn sanctionable. The short answer is yes. So here we go. Let's bump down. In fact, resolution of the issue was never appropriately before the court for the reasons stated in the court's December 7, 2020 ruling. The attorneys who filed the instant lawsuit abused the well-established rules applicable to the litigation process by proffering claims not backed by law, proffering claims not backed by evidence, but instead speculation, conjecture, and unwarranted suspicion, proffering factual allegations and claims without engaging in the required pre-filing inquiry, and dragging out these proceedings even after they acknowledged that it was too late to attain the relief sought. And this case was never about fraud. It was about undermining the people's faith in our democracy and debasing the judicial process to do so. While there are many arenas, including print, television, and social media, where protestations, conjecture, and speculation may be advanced, such expressions are neither permitted nor welcomed in a court of law. And while we, as a country, pride ourselves on the freedom embodied within the First Amendment, it is well established that an attorney's freedom of speech is circumscribed upon entering the courtroom. And let's hit this end note here. We've got a couple of cases they're quoting. The Supreme Court has noted that it is unquestionable that in the courtroom itself, whatever right to free speech an attorney has is extremely circumscribed. In filing motions and advocating for his client in court, an attorney is not engaged in free expression. He is simply doing his job. In that narrow capacity, he voluntarily accepts almost unconditional restraints on his personal speech rights. For these reasons, in the context of the courtroom proceedings, an attorney retains no personal First Amendment rights. Indeed, attorneys take an oath to uphold and honor our legal system. The sanctity of both the courtroom and the litigation process are preserved only when attorneys adhere to this oath and follow the rules, and only when courts impose sanction when attorneys do not. And despite the haze of confusion, commotion, and chaos counsel intentionally attempted to create by filing this lawsuit, one thing is perfectly clear. Plaintiffs' attorneys have scorned their oath, flouted the rules, and attempted to undermine the integrity of the judiciary along the way. We have another citation here. Plaintiffs' counsel and their counsel have suggested that this court's handling of these proceedings and any resultant decision can be expected based on the president who appointed the undersigned. This is part of the continuing narrative fostered by plaintiffs' counsels to undermine the institutions that uphold our democracy. It represents the same bad faith that is the base of this litigation. To be clear, all federal judges, regardless of which president appoints them, takes oaths affirming that they will faithfully and impartially discharge their duties and uphold and protect the Constitution of the United States. As such, the court is duty-bound to grant the motions for sanctions filed by the defendants and intervenor defendants and is imposing sanctions pursuant to Rule 11 of the Federal Rules of Civil Procedure and its own inherent authority. Number 1, procedural history. So they're going to take us through all of the filings that went on here. On November 3rd of 2020, a record 5.5 million Michigan residents voted in the presidential election, resulting in then former Vice President Joseph R. Biden Jr. securing over 150,000 more votes than then President Donald J. Trump. And our footnote here, moving forward, the court refers to the current and former presidents as President Biden and former President Trump, respectively. By the following evening, President Biden had been declared the winner in the state. Even though Michigan law establishes an extensive procedure for challenging elections, plaintiffs did not avail themselves of those procedures as they conceded at the July 11, 2021 motion hearing before this court. Instead, at 11:48 p.m. on November 25th of 2020, the eve of Thanksgiving holiday, plaintiffs registered Michigan voters and nominees of the Republican Party to be presidential electors on behalf of the state, filed the current lawsuit against Michigan Governor Gretchen Whitmer, Michigan Secretary of State Jocelyn Benson, and Michigan Board of State canvassers. The following lawyers electronically signed the pleading: Sidney Powell, Scott Hagerstrom, and Gregory Roll. The complaint listed the following attorneys as of counsel: Emily Newman, Julia Haler, Lynn Wood, and Howard Kleinhendler. On November 29th, a Sunday, plaintiffs filed inter alia an amended complaint and an emergency motion for declaratory emergency and permanent injunctive relief and memorandum in support thereof. The same attorneys who electronically signed or were listed as of counsel on the initial complaint signed or were listed on the amended pleading. The amended pleading also listed Brandon Johnson as additional of counsel. Their amended complaint, plaintiffs alleged 3 claims pursuant to 42 U.S.C. 1983, a violation of Count 1, the Elections and Electors Clause, Count 2, the 14th Amendment Equal Protection Clause, and Count 3, the 14th Amendment Due Process Clause. Under Count 4, plaintiffs asserted violations of the Michigan Election Code. Underlying plaintiffs' claims were their contentions that defendants 1. Failed to administer the November 3rd election in compliance with the manner prescribed by the Michigan legislature in the Michigan Election Code. And 2. Committed a scheme and artifice to fraudulently and illegally manipulate the vote count to make certain the election of Joe Biden was President of the United States. Plaintiffs asserted their claims were supported by the affidavits of dozens of eyewitnesses and the statistical anomalies and mathematical impossibilities detailed in the affidavits of expert witnesses. Plaintiffs attached hundreds of pages as exhibits to their pleadings, some of which included affidavits from individuals and reports from purported experts. Most of these affidavits had been submitted by different lawyers in a prior Michigan lawsuits challenging the 2020 presidential election. These other lawsuits include Constantino v. City of Detroit, Donald Trump for President versus Benson. Plaintiffs cited these materials in support of the factual allegations in their amended complaint and motion for injunctive relief. Plaintiffs asked the court to inter alia decertify the election results and order defendants to transmit certified election results that state that President Donald Trump is the winner of the election. Plaintiffs maintained that this court had to issue this relief by December 8th of 2020 because on that date, the results of the election would be considered conclusive. By December 1st, motions to intervene had been filed by the City of Detroit, Detroit resident and Michigan voter Robert Davis, and the Democratic National Committee and Michigan Democratic Party. As of that date, however, plaintiffs had not yet served defendants with the pleadings or the motion for injunctive relief. Thus, on December 1st, the court entered a text-only order to hasten plaintiffs' actions to bring defendants into the case and enable the court to address plaintiffs' pending motions. Plaintiffs served defendants on December 1st, and the court thereafter granted the motion to intervene and entered an expedited briefing schedule with respect to plaintiffs' motion for injunctive relief. On December 7th, the court issued an opinion and order denying plaintiffs' motion and thereby declining to grant plaintiffs the relief they wanted, which the court noted was stunning in its scope and breathtaking in its reach, as it sought to disenfranchise the votes of more than 5.5 million Michigan citizens who participated in the 2020 general election. The court concluded that plaintiffs' lawsuit was subject to dismissal based on any one of several legal theories. 1, their claims were barred by the 11th Amendment immunity. 2, their claims were barred under the doctrine of laches. 3, they lacked standing. 4, their claims were moot. And 5, abstention was appropriate under the doctrine set forth in the Colorado River case. But the court also concluded that plaintiffs were not likely to succeed on the merits of their claim. As to plaintiffs' claim that defendants violated the elections and elector clauses by deviating from the requirements of the Michigan Election Code, the court pointed out that plaintiffs failed to explain how or why such violations of state election procedures automatically amount to violation of the clauses, and case law did not support plaintiffs' attempt to expand the Constitution that far. Thus, the court found plaintiffs' election and elector clauses claim was, in fact, a state law claim disguised as a federal claim. What is the doctrine of laches? Let me see. Let's see. Right. So usually any of the terms that the term that I would probably use instead of the doctrine of laches would be estoppel. So it really just means that it's already been dealt with. It's already been taken care of. So here they're saying, we've got questions, and under this particular doctrine, they're saying those questions are barred because they've already been answered. Yep. Okay. Great question. All right, where were we? Let's see here. I'm sorry, everyone. I'm on a roll tonight. I'm trying to get through this, but we'll absolutely be doing a in-depth Q&A as I go, probably more towards the end this time. Thus, the court found plaintiff's election and elector clause claim was in fact a state law claim disguised as a federal claim. With respects to plaintiff's attempt to establish an equal protection claim based on the theory that defendants engaged in tactics to, among other things, switch votes for former President Trump to votes for President Biden, the court found the allegations to be based on nothing more than belief, conjecture, and speculation rather than fact. As to the due process claim, the court noted that plaintiffs abandoned it. Yikes. Oh dear. The day after the court issued its decision, attorney Stephanie Lynn Gentilla entered her appearance in this matter and filed a notice of appeal to the Federal Circuit on behalf of the plaintiffs. The notice was updated on December 10th to reflect the proper appellate court, namely the Sixth Circuit Court of Appeals. Ooh, whoa, what? She filed it in the Federal Circuit? What? That's awful. On December 11th, Sidney Powell, Stephanie Gentilla, and Howard Kleinhandler filed a petition for writ of certiorari to the United States Supreme Court. In the petition, when urging immediate Supreme Court review, plaintiff wrote, once the electoral votes are cast on December 14th, subsequent relief would be pointless. On December 15th of 2020, the city served a letter, safe harbor letter, and safe harbor motion on plaintiffs' attorneys, threatening sanctions pursuant to Rule 3 of the Federal Rules of Civil Procedure. Specifically, counsel for the city sent the safe harbor letter and the safe harbor motion via electronic mail and first-class mail to Sidney Powell, Gregory Roll, Stephanie Gentilla, Scott Hagerstrom, Lynn Wood, Howard Kleinhandler. In the meantime, the Supreme Court did not rule on the plaintiff's petition for writ of certiorari by December 14th. And we have a footnote here. The Supreme Court eventually denied the petition on February 22nd of 2021. On December 22nd, Davis filed a motion seeking sanctions against plaintiffs and their counsel pursuant to the court's inherent authority and 28 U.S.C. 1927. On the same day, motions to dismiss were filed by the defendants, the DNCMDP, and the city. The city's motion to dismiss included 4 paragraphs discussing why plaintiffs and plaintiffs' counsel should be sanctioned pursuant to Section 1927. There's our footnote. The city further explained in this motion that it intends to file a motion for a Rule 11 sanction after the safe harbor expires. And all 3 motions to dismiss reflected the concurrence had been sought but not obtained from plaintiffs' counsel. Plaintiffs' response to Davis's sanctions motion was due on January 5th of 2021, and their response to the motions to dismiss were due on January 12th. On January 3rd, plaintiffs filed a motion seeking an extension of time until January 19th to respond to Davis's sanction motions, citing counsel's current assignments and the need for more time to prepare a response. The court granted plaintiffs' request. On January 12th, plaintiffs sought an extension of time, also until January 19th, to respond to the pending motions to dismiss, again citing the need for more time to research the claims advanced in the motions. If you need more time to research the claim in your motion, you have incorrectly prepared your motion. I'm just putting that in here. The court granted this request as well. On January 14th, plaintiffs filed what was docketed as a response to all 3 pending motions to dismiss, but the single response brief addressed only the 1927 sanctions requested in the city's motion to dismiss. On the same day, plaintiffs filed notices voluntarily dismissing this case as to defendants. And the DNCMDP, plaintiffs moved to voluntarily dismiss Davis a few days later. On January 26th of 2021, the parties stipulated to the dismissal of the matter on appeal. So they fought for it, they asked for continuances, and then they voluntarily dismissed it. That's important to note. In the meantime, on January 5th, the city filed a Rule 11 motion for sanctions, for disciplinary action, for disbarment referral, and for referral to state bar disciplinary bodies. On January 28th, Governor Whitmer and the Secretary of State Benson, hereafter the state defendants, filed a motion for sanctions under 28 U.S.C. 1927. All sanctions motions, including Davis's, were fully briefed thereafter. On June 8th, the court scheduled a motions hearing for July 6th, and on June 17th ordered each attorney whose name appears on any of plaintiff's pleadings or briefs to be present. On June 28th, plaintiffs sought to adjourn the hearing due to Gentilla's planned vacation, a request the opposing parties, except Davis, did not contest. The court granted the request, and eventually the hearing was scheduled for July 12th. Prior to the hearing, plaintiffs' attorneys, except Gentilla, retained counsel to represent them. We have 2 footnotes here, or just 1 footnote, number 8. I thought we had another one. Nope. During the July 12th hearing, Donald D. Campbell and Patrick McGlynn represented Hagerstrom, Haler, Johnson, Roll, Wood, Kleinhendler, and Powell, while Thomas Buchanan represented Newman. By the time post-hearing supplemental briefs were filed, Wood and Newman had obtained new counsel. My goodness, there's so many attorneys involved in this. The court conducted an almost 6-hour virtual hearing on July 12th. At the beginning of the hearing, the court explained that each question was directed to all attorneys, and if no other attorney commented or added to the initial response to a question, the court would find that all other attorneys agreed with the answer placed on the record. At the end of the hearing, the court indicated that the attorneys could file supplemental briefs and supporting affidavits, and thereafter entered an order setting deadlines for those briefs. Supplemental briefs were subsequently filed, as were responses thereto. No attorney filed an affidavit. Wow. All right, here we go. Sanctions motions. The state defendants and intervener defendants rely on 28 U.S.C. 1927, Federal Rule of Civil Procedure 11, and the court's inherent authority as sources for sanctioning plaintiffs and or their counsel. In this section, the court summarizes the arguments made in each sanctioned motion. In the next section, the court discusses the law that applies to each source of authority. A. Governor Whitmer and Secretary of State Benson. The state defendant seeks sanctions against plaintiff counsel under Section 1927, or alternatively, the court's inherent authority. The state defendants contend that sanctions are appropriate pursuant to 1927 for two reasons. First, plaintiff's counsel unreasonably and vexatiously multiplied the proceedings in this litigation by failing to dismiss the case when their claims became moot, which plainly occurred upon the vote of Michigan's electors on December 14th, if not earlier. Second, plaintiff's counsel knew or should have known that their legal claims were frivolous, but counsel pursued them nonetheless, even after the court's opinion concluding that the plaintiffs were unlikely to succeed on the merits of their claim for multiple reasons, which included the weakness of their legal claims and the lack of factual support. And the state defendants argue sanctions pursuant to the court's inherent authority are appropriate because plaintiffs' claims were meritless. Their counsel should have known this, and their real motive in filing suit was an improper purpose. In a supplemental brief filed in support of their motion for sanctions on April 6th of 2021, the state defendants also identified three specific allegations that they contend were not well grounded in fact. Number one, the absentee voting counts in some counties in Michigan have likely been manipulated by a computer algorithm, and at some time after the 2016 election, software was installed that was programmed tabulating machines to shift a percentage of absentee ballot votes from Trump to Biden. 2. Smartmatic and Dominion were founded by foreign oligarchs and dictators to ensure computerized ballot stuffing and vote manipulation to whatever level was needed to make certain Venezuelan dictator Hugo Chavez never lost another election. 3. The several spikes cast solely for Biden could easily be produced in the Dominion system by preloading batches of blank ballots in files such as write-ins, then casting them all for Biden using the override procedure to cast write-in ballots that is available to the operator of the systems. Again, these are three specific allegations that were not grounded in facts. For clarification on that one. So that was the governor and the Secretary of State. Next, we have the city of Detroit. The city seeks sanctions against the plaintiffs and plaintiffs' counsel for violating Rule 11. The city first argues that the complaint was filed for an improper purpose, in contravention of Rule 11b1. The city supports this assertion by pointing to 1, the hurdles that previously barred plaintiffs' success, including the 11th Amendment immunity, mootness, laches, standing, and the lack of merit as to the claims under the Constitution and state statutory law. 2, the lack of seriousness and awareness of deficiency evinced by plaintiffs' failure to serve defendants before this court hastened them via its December 1st, 2020 text-only order. And 3, plaintiffs' counsel's attempt to use this court's process to validate their conspiracy theories, undermine our democracy, and overturn the will of the people, as evinced by statements made by some of the plaintiffs' attorneys. The city also contends that plaintiffs' claims were not well grounded in law, in a contravention of Rule 11b2. This is so, the city argues, not only because of the 11th Amendment immunity, mootness, laches, and standing, but also because the factual allegations could not support plaintiffs' claim or the relief they requested. The city further contends the plaintiffs' allegations were not well grounded in fact, in contravention of Rule 11. So I'll take you through these. Again, these are not facts, and you're not allowed to plead things that are not facts. All right, that is like rule number 1, legal research and writing. Number 1, plaintiffs alleged that Republican challengers were not giving meaningful access to the ballot processing and tabulation at the absent voter counting board location in Hall E of the TCF Center, knowing that the assertion lacked evidentiary support because it was rejected in Constantino, which was the previous filed case. The state court case decided before plaintiffs filed the complaint. Plaintiffs alleged that the Republican challengers were exclusively barred from entering the TCF Center, knowing that the assertion was rejected in Constantino. Plaintiffs alleged that some absentee ballots were predated, knowing that the assertion was rejected in Constantino. Plaintiffs allege that ballots were counted more than once, knowing the assertion was both rejected in Constantino and conclusively disproven by the Wayne County canvass. Plaintiffs allege that a software weakness in Dominion machines upended Michigan's election results, knowing that 2 instances of errors to which plaintiffs cite, one in the Antrim County and one in Oakland County, Rochester Hills, did not constitute evidentiary support for the allegation. 6. Plaintiffs intentionally lied by filing the partially redacted declaration of Spider, who plaintiffs identified as a former U.S. military intelligence expert. Hold on. What? Wait a minute. What? Plaintiffs intentionally lied by filing the partially redacted declaration of Spider. Is this a person? Oh my goodness. Who plaintiffs identified as a former U.S. military intelligence expert. What? This is madness. And former electronic intelligence analyst with the 305th Military Intelligence, which was signed by Joshua Merritt, who never completed the entry-level training course of the 305th Military Intelligence Battalion and is not an intelligence analyst. Well, that's not good. You don't want to claim, Spider's no good. No Spider. Spider. Oh my goodness. Plaintiffs intentionally lied by filing the declaration of Russell James Ramswald Jr., who claimed, 1, that there were reports of 6,000 votes in Antrim County that were switched from Donald Trump to Joe Biden and were only discoverable through a hand-counted manual recount, when there were no hand recounts in Michigan as of that date. 2, statistically improbable voter turnouts, including a turnout of 781.91% in North Muskegon, where the publicly available official results were known as of election night to be approximately 78%, and the turnout of 460.51%, or elsewhere on the same chart, 90.59%, in Zeeland Charter Township, where it was already known to be 80%. And 3, that ballots can run through, again, effectively duplicating them, when there were safeguards in place to prevent double counting of ballots in this way. And number 9, plaintiffs intentionally lied by filing an analysis of William Briggs, who relied on survey results posted in a tweet by Matt Brainyard, and the survey misrepresents Michigan election laws, disregards the standard analytical procedures, contained a baffling array of inconsistent numbers, and includes conclusions that are without merit. Wow, like every single piece of evidence is incorrect. My goodness. The city maintains that monetary sanctions sufficient to deter future misconduct by council must include the amount council collected in their fundraising campaign to challenge the 2020 election, as well as the attorney's fees defendants incurred to defend against plaintiffs' claims. The city also seeks an injunction barring plaintiffs and their counsel from filing future actions in this district without obtaining approval from a judicial officer, and asks the courts to refer counsel to discipline and disbarment. Whoa! So the city is saying you're not allowed to even file in our jurisdiction again without pre-approval. Oh my goodness. All right. Footnote. The city also argues this is a rare case where the plaintiffs themselves deserve severe sanctions. Rule 11 expressly provides the district court with discretion to impose sanctions on a party that's responsible for the rule's violation, provided that the violation is not one for unwarranted legal contention under Rule 11b2. Nevertheless, courts generally decline to do so, and the Sixth Circuit has reserved such sanctions for occasions when the party can be said to have caused a violation. The court is unable to reach that conclusion here, particularly given that it's plaintiffs' counsel, not plaintiffs, who have filed similar legally frivolous lawsuits in other battleground states. Whoa, that's harsh. That's pretty harsh, everybody. All right, before I get into Davis, let me grab a cup of tea here real quick. All right, Davis. So this is our third set of defendants seeking sanctions. Davis seeks sanctions against plaintiffs and their counsel pursuant to the court's inherent authority under Section 1927, based on many of the same legal and factual deficiencies set forth by the state defendants, the city, and this court in its December 7th decision. All right, so here's the applicable law. Sanctions pursuant to 28 United States Code 1927. 1927 provides that any attorney who so manipulates the proceedings in any case unreasonably and vexatiously may be required by court to satisfy personally the excess of costs, expenses, and attorney's fees reasonably incurred by such conduct. The purpose of a sanctions award under this provision is to deter dilatory litigation practices and to punish aggressive tactics that far exceed zealous advocacy. Section 1927 imposes an objective standard of conduct on attorneys, and courts need not make a finding of subjective bad faith before assessing monetary sanctions. A court need only determine that an attorney reasonably should have known that a claim pursued is frivolous. Simple inadvertence or negligence, however, will not support sanctions under 1927. All right. And then we're citing case law here, so let me bump over. Ultimately, there must be some conduct on the part of the subject attorney that trial judges applying collective wisdom of their experience on the bench could agree falls short of the obligations owed by a member of the bar to the court. B, sanctions pursuant to Rule 11B and C. A footnote here. Although the court mentioned the availability of imposing Rule 11 sanctions on its own initiative during the July 12th hearing, it recognizes such sanctions must be preceded by a show cause order, which was not issued here. Moreover, for the reasons discussed infra, the court need not rely on that authority to sanction plaintiff's counsel. Rule 11B reads in part, by presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney certifies to the best of the person's knowledge, information, and belief, formed after inquiry, reasonable under the circumstances. It is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. The claims, defenses, or other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing a new law. And 3, the factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support. Again, this is just the basic knowledge we all are taught after a reasonable opportunity to further investigation or discovery. None of the allegations in the amended complaint contain specific reference to the need for additional factual support for investigation or discovery, as plaintiffs pled on information and belief in only 3 of the amended complaints, 233 paragraphs. One of those paragraphs does not contain a fact asserted upon the information and belief, but seems to be concluding that facts asserted elsewhere reflect upon information and belief. Defendant's failure to follow proper election protocol. Another of those paragraphs relate to when a co-inventor of a certain Dominion-related patents joined Dominion's predecessor, and all other relates to plaintiff's allegation that defendants failed to post certain absentee ballot information before certain times on election day. Plaintiffs have not availed themselves of Rule 11's allowance for claims that will likely have evidentiary support after a reasonable opportunity to further investigate or discovery, except for arguably in the latter 2 instances. So in other words, they had absolutely no facts or evidence backing up anything that they put in their pleadings, and that's not allowable. Much of the italicized language was added to Rule 11 in 1993. Also added in 1993 was a provision to subsection C allowing for the sanctioning of attorneys other than presenters who are responsible for a violation of the rule. As the advisory committee notes explain, the revision permits the court to consider whether other attorneys in the firm, co-counsel, or other law firms, or the party itself should be held accountable for their part in causing a violation. Any sanction imposed pursuant to Rule 11 must be limited to what suffices to deter repetition of the conduct or comparable conduct by others similarly situated. This is because the central purpose of Rule 11 is to deter baseless filings in district court. Thus, even if the careless litigant quickly dismisses the action, the harm triggering Rule 11's concern has already occurred, and the imposition of such sanctions on abusive litigants is useful to deter such misconduct. Rule 11 de-emphasizes monetary sanctions and discourages direct payouts to the opposing party. The amended rule recognizes, however, that under unusual circumstances, deterrence may be ineffective unless the sanction not only requires the person violating the rule to make a monetary payment, but also directs that some or all of this payment be made to those injured by the violation. Yikes. In addition, a variety of possible sanctions are available under Rule 11, including but not limited to requiring participation in seminars or other education programs, ordering a fine payable to the court, and referring the matter to disciplinary authorities. In the Sixth Circuit, the test for imposing Rule 11 sanctions is whether the individual's conduct was objectively reasonable under the circumstances. To determine objective reasonableness, the court must ask whether the position advanced by a party was supported by a reasonable inquiry into the applicable law and relevant facts. Whether a reasonable inquiry was conducted is judged by the objective norms of what reasonable attorneys would have done. I'll tell you right now, as a reasonable attorney, we would not have done this. Okay, done. Done. It's decided. Courts must not use the wisdom of hindsight, but must instead test what was reasonable to believe at the time the pleading motion or other paper was submitted. This objective standard is intended to eliminate any empty head, pure heart justification or patently frivolous arguments. A good faith belief in the merits of a case is insufficient to avoid sanctions. All right, here we go. Signatures. Plaintiffs' lawyers argue that no attorney can be sanctioned whose names appeared only in typewritten form, that no attorney besides the plaintiff's local counsel has appeared or signed a document filed in this matter, and that the court lacks jurisdiction to sanction any attorney who did not personally appear or sign a document filed in this matter. Really? They're saying they can't be sanctioned because they didn't personally sign it. What? Yet the local attorney asserts that, although they signed the filings, they did not prepare them and thus should not be responsible for them. Oh my goodness. As such, no attorney wants to take responsibility now that sanctions are sought for filing this lawsuit. In this age of electronic filing, it's frivolous to argue that an electronic signature on a pleading or a motion is insufficient to subject the attorney to the court's jurisdiction if the attorney violates the jurisdiction's rules of professional conduct or a federal rule or statute establishing the standards of practice. As set forth earlier, Sidney Powell, Scott Hagerstrom, and Gregory Roll electronically signed at least the complaint, amended complaint, and motion for injunctive relief. The remaining attorneys except Gentilla were listed as of counsel on one or more pleadings. Here's our footnote here. Gentilla, however, did sign and docket subsequently filed motions, briefs, or other papers in which she and plaintiffs' remaining attorneys advocated the claims asserted in their pleadings. Indicating to counsel present to the court in a pleading, written motion, or paper by inter alia signing, filing, or latter advocating it. The cases plaintiffs cite in support of their argument that non-signing attorneys cannot be sanctioned were decided before the 1993 amendment to Rule 11. All right, this right here, I would say, is grounds for sanctions. You don't get to cite law that was used before the rule. That's bad. You shouldn't do that. For purposes of Rule 11, an attorney who is knowingly listed as counsel on a pleading, written motion, or other paper expressly authorized the signing, filing, submitting, or later advocating the offending paper and shares responsibility with the signer, filer, submitter, or advocate. Footnote 14, at the July 12th hearing, Wood asserted for the first time that he was oblivious to his inclusion as counsel for plaintiffs in this case. The court will address this assertion separately. Wood's going to get its own section. All right, here we go. Oh, dear. Oh, my goodness. The court need not go through mental gymnastics, as pre-1993 courts sometimes felt compelled to do, in order to hold attorneys accountable under Rule 11. Notably because Rule 11 only requires a signature by at least one attorney. Documents are frequently presented to federal courts which list several attorneys as counsel but contain the signature of only one. Regardless, as amended in 1993, Rule 11 allows for sanctions on any attorney that violated the rule or is responsible for the violation. Moreover, Michigan Rule of Professional Conduct 8.5a reads, "A lawyer not admitted in this jurisdiction is also subject to the disciplinary authority of this jurisdiction if the lawyer provides or offers to provide any legal services in the jurisdiction." Oh, goodness. By agreeing to place their names on the pleadings and or motions, counsel are responsible for those submissions and will be held accountable. Footnote 15, although the issue of whether non-signing attorneys can be sanctioned is discussed in Rule 11 section, the court concludes for the same reasons that they can be sanctioned under Section 1927 and the court's inherent authority as well. The same is true for Wood, Newman, and Roll, who are discussed in the next subsections. All right, now we're getting into it. Yikes. So now we will go through what these attorneys specifically did, what their involvement was. At the July 12th hearing, Wood maintained that the court lacks jurisdiction to sanction him because he played no role in drafting the complaint, did not read any of the documents with respect to the complaint, was not aware of the affidavits attached to it, and did not give permission for his name to be specifically included in this action. When the court asked Wood if he gave permission to have his name included on the pleadings or briefs, Wood answered, "I do not specifically recall being asked about the Michigan complaint, but I had generally indicated to Sidney Powell that if she needed a quote-unquote trial lawyer, that I would certainly be willing and available to help her." Footnote 16. Wood therefore admittedly offered to provide legal services in this jurisdiction. In this case, obviously my name was included. My experience or my skills apparently were never needed, so I didn't have any involvement with it. Would I have objected to be included by name? I don't believe so. Thank you, Mr. Wood. The court then asked Wood if he gave Powell permission to include his name on the filings in this matter, to which he responded, "I didn't object to it, but I did not know. I actually did not know at the time that my name was going to be included, but I certainly told Miss Powell in discussions that I would help her if she needed me in any of these cases, and in this particular matter, apparently I was never needed, so I didn't have anything to do with it." Wood then denied being served with the motion for sanctions and stated he was present only at the hearing because the court required him to be there. According to Wood, he only discovered that he had been included as counsel for plaintiffs in this matter when he saw a newspaper article about the sanctions motion. "I didn't receive any notice about this until I saw something in the newspaper about being sanctioned." When the court turned to Powell and asked whether she told Wood his name was being placed on the pleading, Powell first answered, "My view, Your Honor, is that I did specifically ask Mr. Wood for his permission. I can't imagine that I would have put his name on any pleading without understanding that he had given me permission to do that." I'm sorry, I can't do Powell's low voice. Everybody, I'm so sorry. I can't go as low as Miss Powell. I'm sorry. All right, hold on, everybody. I need to recover from that one. She has the lowest voice. Oh my goodness. Okay, I'm trying. Hopefully Miss Powell will not be in here anymore. Powell then suggested that perhaps there was a misunderstanding between her and Wood. Number 17. The existence of a misunderstanding seems improbable given that several similar lawsuits seeking to overturn the presidential election results were filed in Georgia, Wisconsin, and Arizona, each bearing the same of counsel listing for Wood as appears here. Wood moved for pro hoc vice admission in the Arizona proceedings. He did not do so in Wisconsin, but like Michigan, the district court for the Eastern District of Wisconsin does not permit pro hoc vice motions. That's suspicious, Mr. Wood. Anne Kleinhendler did not recall whether he spoke to Wood before Wood's name was included on the pleading. The court does not believe that Wood was unaware of his inclusion as counsel in this case until a newspaper article alerted him to the sanctions motion filed against him, and this is why. Uh-oh. Getting into an outline format, you know it's going to be good. First, the city's motion for sanctions was filed on January 5th of 2021. At no time between the date and the July 12th hearing did Wood ever notify the court that he had been impermissibly included as counsel for plaintiffs in this action. Almost a month before the motion hearing, the court entered an order requiring each attorney whose name appears on any of the plaintiff's pleadings or briefs to be present at the hearing. Wood still did not submit anything to the court claiming that his name was placed on those. It's not looking good for Mr. Wood here. Filings without his permission. No reasonable attorney would sit back silently if his or her name were listed as counsel in a case if permission to do so had not been given. Second, Wood is not credible. Ouch. Ow. That's not very nice. Oh my goodness. Let's see what we've got here. What? Notably, while Wood stated at the July 12th hearing that he only learned about the motion seeking sanctions against him when he read about it in a newspaper article, Wood suggests in his supplemental brief that he in fact learned of his purported involvement in the lawsuit when he received a call from one of the attorneys in this matter in mid to late June of 2021, alerting him to the court's order requiring him to appear at the hearing on the sanctions motions. Oh, tricky briefs. Those timings, very important. Whoopsies. Yeah, whoopsies. He claims he was never served with the city's motions for sanctions. However, counsel for the city represents that the motion was sent to Wood via email and regular mail. Kimberly Hunt, the office manager for the city's attorneys, affirms that an affidavit that she mailed the first-class U.S. mail, a copy of the safe harbor letter and the safe harbor motion to Wood, among others, on December 15th of 2020, and that no copies were returned as undeliverable. And despite being told that he had the opportunity to attach an affidavit to his supplemental brief in order to put his oath behind his factual assertions, Wood surprisingly chose not to do so. Got footnotes 19 and 20. Yikes. Wood asserts in his supplemental brief that he and his legal assistant have performed a diligent search of all email correspondence as well as U.S. mail in Mr. Wood's Atlanta office and elsewhere. They have turned up no evidence to indicate they were provided with any Rule 11 notice prior to the filing of the motion. Yet no affidavit is offered from Wood or his legal assistant to attest to these assertions, and notably the address listed for Wood on the filings in this matter, and thus where the city attorneys mailed items to him, is a post office box, not his firm's address. 20. Wood contends that he's entitled to a full evidentiary hearing should the court determine that material factual questions do exist, so that he may present to the court with the evidence of record sufficient to establish the factual representations made in his supplemental brief regarding why this court does not have jurisdiction to sanction him. He's entitled to no such thing. Citing case law. Recognizing that an evidentiary hearing is not necessarily required when the court has full knowledge of the facts and is familiar with the conduct of the attorneys. Ouch. The July 12th hearing provided Wood the opportunity to present his evidence, and as noted supra, he had the further opportunity to attach an affidavit as evidence to his supplemental brief. The court is not impressed. More importantly, Wood's social media postings undermine his current... Oh, no. Wood. No, you didn't, did you? No. Come on. Undermine his current assertions, as do his statements in other court proceedings. As discussed during the July 12th hearing, on the day the city emailed copies of the safe harbor letter and safe harbor motion to plaintiff's counsel, Wood tweeted a link to an article containing a copy of the motion, stating... When you get falsely accused by the likes of David Fink and Mark Elias in a propaganda rag like Law and Crime, you smile because you know you are over the target and the enemy is running scared. Oh dear, oh dear. Oh dear. On January 5th of 2021, the day the city filed the motion, Wood tweeted a link to an article with the motion stating that it was unfair for the city to seek sanctions against him. In a federal courtroom in the Eastern District of New York on January 11th, Wood acknowledged that the city was trying to get him disbarred. Even more importantly, prior to the July 12th hearing, Wood took credit for filing this lawsuit. Footnote 21. Notably, Rawls stated under oath that Wood, along with Powell, spearheaded the lawsuit. Though the court hesitates to rely too much on the assertions of any of the plaintiffs' attorneys because their positions as counsel for the city aptly describes having been like shifting sands, the court notes that Rawls' sworn affidavit was attached to a supplemental brief filed by plaintiffs' counsel in response to the city's motion for sanctions. No member of plaintiffs' legal team objected to any part of Rawls' affidavit. Ouch, that's another burn. Yeah, that's a pretty harsh burn. In a brief submitted to the Delaware Supreme Court, Wood claimed through counsel, Wood represented plaintiffs challenging the results of the 2020 presidential election in Michigan and Wisconsin. In the days and weeks following the general election of 2020, Wood became involved in litigation